Okay, we're back with WMU Political Science 3250, and this is online learning number 4. We'll put that out there. So, online learning number 4 to follow up 1, 2, and 3. This is the last online learning prior to the second examination. So, keep in mind that you should have reviewed online learning number 1, number 2, 3, and 3B, and now number 4, plus the material since the first exam for us for the second exam. After this particular online learning, though, we'll move into the last phase for the final exam, but you will not need to know anything beyond online learning number 4 for the second exam. The topic I want to talk about in this regard is bail. This is the period of time after somebody has been charged and before the case is resolved, either at a trial or at a plea. There's an issue of what's known as bail. The Eighth Amendment speaks to the issue of bail. If you go to the Eighth Amendment, it will say that excessive bail shall not be required. So it's an important constitutional issue, and it requires and demands of the courts that they not impose an excessive bail as the case is progressing. Bail exists from the period of time in which a person is charged until the resolution of the case, either because it's dismissed, they're found not guilty, or the person is found guilty and ultimately sentenced. There is one caveat to that, which is known as interim bail, which I'll talk about here in a moment. So let's go back a little bit to the history of bail. The purpose of bail in the beginning, when this first came out, was to set a dollar amount that would ensure the return of someone charged with a crime to come back to court to resolve the case. That was the point in setting bail, was to fix a certain dollar amount that was appropriate to ensure that the person would come back to court. So let's look at it from today's perspective. If somebody's charged with murder and you set a $500 cash bail, is that a dollar amount that is sufficient to ensure that the person would come to court? The answer for most people would probably be no. That is, if I had to post $500 to get out of custody and then I could flee the jurisdiction, too bad. I lose my $500, but at least I don't have to stand trial on a murder charge. So the idea being is taking into consideration what the individual is charged with and their financial means, as well as their connections to the community, and trying to fix a dollar amount that is the right amount of money that would cause a person not to flee because they have posted a significant amount of money. That's the original purpose behind bail. Over time, the court, that is the Supreme Court, has permitted bail to also include the safety of the public. So we're not only interested in would the person return to court, but also the safety of the community in setting bail. So now there are two things to look at when we set bail. Again, prompt return to court when they're supposed to resolve the case, as well as the safety of the public. Admission to bail, that is when a court grants bail, always involves a risk that the person would take flight, that is run from the jurisdiction. It's a calculated risk, and that's a risk that we include within the price of our system of justice. In allowing bail, the duty of the judge is to reduce that risk by fixing an amount reasonably calculated to hold the accused available for trial, as well as the safety of the public. There has been language along the way, and this is a good definition here, that the amount of bail shall be such as in the judgment of the court will ensure the presence of the defendant, having regard to the nature and circumstances of the offense charged, the weight of the evidence against him, the financial ability of the defendant to give bail, and the character of the defendant. So what the court is interested in is determining all of this information, that is, gathering as much information such that when a person stands in front of them, they fix an appropriate amount of bail to ensure that they come back to court and that the community is safe having them about. So In Michigan, what kind of bail do we have? Well, we have a number of types of bail, and I got a little chart here that I put for you to help explain what the bail is. The first one, and if you want to write these down, and I'll explain them. The first in is OR bond, known as own recognizance bond. There's a dollar amount of personal recognizance bond. There's what is known as a cash bond. There's a surety bond. And then, in certain circumstances, bond can be denied. So those are the various types of bond that a trial court can set on a case that is pending before it's resolved. Let's look at the first one, own recognizance bond, commonly referred to as OR bond. And when I say bond, I mean the same thing as bail. Bail and bond are interchangeable. So what is exactly an OR bond? OR means that the person promises to return to court. That's all that it is. It is a promise that they'll return to court. There is not any conditions on their behavior, and there's no money associated with it. So if somebody's charged with a crime, after gathering the information about the crime, the risk of flight, the seriousness of the crime, the person's criminal history, if a judge sets an OR or own recognizance bond, it is obvious that the judge does not want to impose a significant financial restraint on the individual. More often than not, this is given in a misdemeanor case. If you were charged with trespassing or charged with open intoxicants or charged with shoplifting, it's a pretty good scenario such that the court would give you an OR bond that you simply promise to show up in court. And if you don't show up in court, then the judge might issue a warrant to have you arrested for not showing up, but you're not out of financial responsibility. So that's the lowest level. That is the easiest one, obviously, to get to be released on, I should say, and more often is given in misdemeanor type cases. The next more restrictive bond is known as a personal recognizance bond. And with that, there's a dollar amount attached. So, for example, if a judge issued a $1,000 personal recognizance bond, what that means is that the individual doesn't have to actually give the court any money in order to get out of jail while the case is pending. What it means is that the individual promises that if they do not comply with the bond terms, that is showing up back in court, and if there's other restrictions on their behavior, then they promise they're good for $1,000. In other words, they do not have to give any money to get out of custody, but they assure the court that they'll do what they're supposed to and avoid doing what they're not supposed to while the case is pending. And if they violate the terms of their bond, then they're good for the dollar amount. So that's known as personal recognizance bond. A little bit more restrictive than the OR bond, but still no money actually has to exchange hands in order for an individual to be released from custody. The next one is a cash bond, and it's exactly what it means. If a judge sets a $1,000 cash bond, then the individual, in order to get out of custody or jail, they actually have to give to the court $1,000 in cash. Not something of value of $1,000, but $1,000 in cash. And if they don't, then they remain in custody until the case is resolved or until bond changes. So again, cash bond is actual cash that has to be delivered. The next one is what is known as a surety bond, and cash and surety bond oftentimes are interchangeable. What surety means is that if I set a $1,000 surety bond, then the individual has to post something of value of $1,000. That is the title on a motorcycle, for example, or something else that is valued at $1,000. This way, someone doesn't have to liquidate that which they own. They can actually put the title of property up to assure the court that they're going to return to court and comply with the terms of the bond. If they flee the jurisdiction or don't comply, then the court gets the title on the property, whatever it may be. Cash and surety bond are generally interchangeable. The court is interested in something of value, whether it be the actual cash or something tangible, to satisfy the dollar amount that was set in their bond. Of course, the final one then is bond denied. There are limited circumstances when the court can deny somebody's bond. In Michigan, if somebody is charged with murder, then their bond can be denied. Their bond can also be denied if they're charged with a capital type of case, not murder, if it was maybe armed robbery or first-degree sexual assault. If they were charged with that type of serious crime and they were currently on probation when the alleged event occurred, then a judge may deny their bond until the pendency of the case. So those are the various types of bond that begin once somebody is charged. So if we go back in time and we think about arraignments, when an individual comes before me, I arraign them on the criminal charges, explain them what those charges are and their rights. The person enters a not guilty plea or stands mute. I schedule it for the next appropriate hearing. And at the same time, I set a bond to apply between the moment of arraignment until the next hearing and then eventually to the resolution of the case. That's when the court sets the bond or the bail, interchangeable again, and the Eighth Amendment restricts me from setting what is known as an excessive bail. I'm not allowed to impose an excessive one. And as I mentioned, I look at the nature and circumstances of the charge that they are facing, the weight of the evidence apparently against him, the financial ability of the accused, as well as their character. That may also include ties to the community, whether or not they have ties outside of the community, things of that nature. So that's bond and or bail. Let me talk about conditions of bail or bond. The court is permitted to, on top of requiring somebody to give some money when it's a cash or surety bond, or to make a promise when it comes to a personal recognizance or own recognizance bond, the court can also impose conditions. That is, you're not allowed to go visit or see the victim of the crime. If it's a drug-related offense, I may impose a condition that says you have to enroll in a substance abuse or drug counseling program. I may also preclude you from possessing a firearm or possessing alcohol, depending on the nature of the charges. I may restrict your ability from leaving the state of Michigan, for example. These restrictions are also permitted as conditions of bond. So on one hand, you have the financial end. On the other hand, you also have restrictions on freedom of movement. I impose those restrictions when they are appropriate given the severity of the charges that they're facing or the type of charges that they're facing. So there's two aspects when it comes to the issue of bail, financial as well as restrictions. Some people ask the question, where does a bondsman come into this entire equation? And that's a legitimate question. As you might imagine, if you're given an OR or a personal recognizance bond or bond denied, a bondsman wouldn't help you out. There's no need to get a bondsman for an OR or personal recognizance bond because you don't owe any money in order to get out of custody. And for a denied bond, you're not going anywhere, so a bondsman's not going to help you. What happens with a bondsman is generally regarded when you're given a surety bond. And let me explain as succinctly as I can what it actually means. If I'm your judge and you come before me and I set what is known as a $5,000 surety bond, what that means is that you have to put up something of value of $5,000 to get out of custody. What if you don't have anything of value of $5,000? Well, if that's the case, then you'll stay in custody. But if you have access to somebody who might have something of value of $5,000, then that person might put that whatever valuable thing is up to get you out of custody. That's where a bondsman comes into play. So your $5,000 surety bond, you don't have $5,000, you have maybe a few $100s to your name. You go to a bondsman and say to the bondsman, listen, if I give you $500, would you put up a guarantee to the court of $5,000 to allow me to get out of custody? And that's what a bondsman will do. A bondsman will take a percentage of the bond amount and then put up as collateral, surety, whatever they need to do in order to ensure the person will return to court. That's where the bondsman gets his employment. Normally, it's about 10%. That is what the bondsman takes, and that money is never returned to the individual. That's how the bondsman actually makes money. In other words, if it's a 5,000 surety bond, the individual gives the bondsman $500. The bondsman then tells the court, I guarantee to the tune of $5,000 that my client will return to court. The person gets out of custody. He runs around in the community. If he doesn't show up in court, then what the court can then turn to is the bondsman and say, give me my $5,000, because the bondsman is guaranteeing the individual would be there. And if they don't show up, the court can go after the bondsman for that $5,000. So there's an interest in the bondsman making sure that the client, the defendant, shows up in court. And that's where you get employment that you might hear about, like bounty hunters. They go after the individuals who might have fled the jurisdiction to get them to come to court. Why? Because the bondsman is out the significant amount of money when the individual doesn't show up. So that's how a bondsman works. Bondsman generally is found with respect to the surety bond. If it's a cash bond, normally a bondsman wouldn't do that. They wouldn't put up cash to get somebody out of custody. There may be a bondsman that might choose to do that, but normally it's done in the surety realm. So those are the various types of bonds. Again, they apply once the individual is charged with a crime until the resolution of the case. Now, there is one type of bond that exists prior to charge after arrest. So in that window between an arrest and the charge, sometimes the jailer, the sheriff who's in charge of the inmate who's in custody, might set what is known as an interim bond, interim. That is the type of bond to exist between when the person was arrested until they get arraigned. Generally, that's an overnight, or maybe if it's a weekend, it's a couple of days. In that situation, a sheriff might choose to say to someone who they arrested, I'm going to set an interim bond for you. And if you post that bond, then you can get out of custody until your arraignment date, either the next day or the next business day. The purpose of that is, of course, to allow the sheriff to control and manage the population at his jail. If on a Friday night, when school comes back into session, there happens to be a bunch of parties going on and the sheriff chooses to arrest 30 people because of behavior that might have occurred on a school party night, and people are arrested for being drunk and disorderly and what have you, the sheriff might issue interim bonds because he doesn't want to hold on to those people for 24 or 72 hours until they're arraigned, because it's too crowded at the jail and they're relatively minor type of offenses. So the sheriff might give what is known as an interim bond. Tell the person, you've been arrested, your court date's coming up here, and you owe me some money in order to get out of custody. The interim bond can't be anything more than 20% of whatever the maximum fine is on the reason why they are arrested. So if we look at an example of misdemeanors, most misdemeanors, the maximum fine is $500, which means that a sheriff might set an interim bond of up to $100 to allow a guy who got arrested tonight to get out of jail and then report to the court tomorrow for his arraignment. That's how an interim bond works. Individuals who are in custody have no right to get an interim bond. It's only at the discretion of the sheriff when the sheriff chooses, because of population control, to get some of the people out of jail who have not yet been arraigned. Once the individual is arraigned, then the court's issued bond takes over. So, give a perfectly common example. You get arrested tonight because of doing something you shouldn't have been doing. Maybe it's a minor misdemeanor, and you have $100 in your pocket, and the sheriff issues an interim bond and says, show up tomorrow to the court for your arraignment. You give the sheriff the $100, you show up in front of me to be arraigned, I tell you the charges, you plead not guilty, I discover that you've already given $100 to the sheriff, and I simply set a bond at $100 and continue the case. And we'll use that $100 interim bond as your bond as the case is progressing. That's a very common occurrence when it comes to misdemeanors, and it happens because the sheriff chooses not to hold you in custody longer than he really needs to do so. So that's a good discussion on the issue of bail or bond. And again, it applies until the case is resolved. The next thing I want to talk about is what happens after the arraignment. And so let me use my little chart here and talk about our little timeline. I have to cross off that which I had, that was bail. And we'll put on here after the crime was committed and we had an investigation. And we had an arraignment. Okay, so this is just a brief little look at what's going on. So we got a crime, the person was charged and they were arraigned. That is, again, informed of the charges. Person, if they choose to plead not guilty or stand mute, the case hasn't been resolved yet, so we move down the timeline. Bond is set here at the arraignment and continues. And I want to talk about this procedure that's known as a preliminary examination. I put P-exam for short, but it is what is known as a preliminary examination. So let's spend a minute talking about that, and then we'll close out our discussion for the material prior to the second examination. A preliminary examination is not a constitutional matter. Many states have created statutes which say that an individual who's accused of a felony has the right to what is known as a preliminary examination within a certain number of days after they were arraigned. In Michigan, we generally set it at 14 days. So within 14 days of the arraignment, an individual has the right to a preliminary examination, sometimes referred to as a probable cause evidentiary hearing. And what that is an opportunity for the defendant to force the prosecutor to present admissible evidence to support the charges against the individual. Remember, up to that point in time, the prosecutor has not had to come into court with the threat of cross-examination of a defense attorney about the evidence. We know that the prosecutor or government needs to have probable cause to arrest somebody. We know that they need to have probable cause at a minimum in order to get a grand jury indictment. They need to have probable cause to issue an actual complaint against a person. So we know that probable cause is used in order to pursue this criminal prosecution. But up until the arraignment, there's no requirement on the part of the government to present that evidence in open court. They can have hearsay evidence. They can have somebody's version of events that support probable cause. You can have a silent observer tip that might support probable cause. All of that stuff still needs to support probable cause, but not in open court. With the preliminary examination, the prosecutor must establish probable cause evidence of admissible evidence in court. That is, withstands the rules of evidence, where you need to have a witness who shows up and testifies to actually what happened, with cross-examination by the defense attorney of the issue. Remember, the person has the right to have a lawyer present for every critical stage after they are arraigned. One of those critical stages is this preliminary examination. I like to refer to the preliminary examination as a mini trial. It is a hearing that is held in front of a judge, not a jury, and that judge receives evidence from the government, where the defense has the opportunity to present their own evidence, as well as cross-examine the prosecution's evidence. And if the judge is satisfied that there is probable cause, admissible evidence of a crime, then the case continues down the path towards a trial. If the prosecutor has not presented admissible evidence of probable cause of a crime, then the case is dismissed. So it's a critical stage of the proceeding. It's important that a defendant has a right to have a preliminary examination, because on felony matters, there's more likely than not a chance the person's going to be sitting in custody. And if the trial isn't put off for 3 or 4 months, then for 3 or 4 months, without this preliminary examination, the person just remains in custody until the actual trial. This type of hearing gives the defense at least a general idea whether or not the witnesses are going to cooperate, The victim is going to remember what happened. The police investigation has moved along such that they have at least a modicum of evidence to prove that the person committed a crime. They don't have to prove, that is, the government doesn't have to prove beyond a reasonable doubt that a crime occurred, just admissible evidence to support this threshold that we've been talking about, known as probable cause. All of this, that is the arraignment and the preliminary examination in the state of Michigan for state crimes, happens in the district court. As I mentioned, long time ago, we have two different types of trial courts, mainly in Michigan. We have the district court, which handles misdemeanor matters, as well as the early stages of felonies, and circuit court, which handles the secondary stages of felonies. This is an early stage of a felony. And so when we have an arraignment after a person has been charged with a crime and they have a preliminary examination, all of this happens in district court for state crimes. If after the preliminary examination there is sufficient evidence to have this case go to trial, it is what is known as bound over to circuit court, BOUND. It's called a bind over. Move the case along and it goes to a circuit court judge and leaves the district court. So, to recap this whole little procedure when it comes to felonies, person is arrested, they're charged with a crime and arraigned, it happens in front of a district court judge, that district court judge sets bail, there's a preliminary hearing held within 14 days of their arraignment, where there's admissible evidence presented, again, in front of a district court judge. If that district court judge is satisfied that there's probable cause evidence of a crime, then they bind the case over to circuit court, and the circuit court judge then picks up the case and carries it to its conclusion, that is a trial or sentencing. If there's insufficient evidence to bind over, the case is dismissed, and it never makes its way to circuit court. It stays in district court and is dismissed. That's what happens with state court felonies in Michigan. Now, what happens to misdemeanors? Well, misdemeanors never make their way to circuit court. As I mentioned months ago, a misdemeanor remains always in district court. Because misdemeanors between the arraignment and the resolution of the case generally happen relatively quick, and there's generally not many of those people that remain in custody during that period of time, the state of Michigan does not afford individuals charged with misdemeanors the right to a preliminary examination. So preliminary examinations only apply to felonies. And everyone charged with a felony has the right to a preliminary examination. Now, oftentimes, an individual may waive their right to have a preliminary examination. Why would this ever happen? Well, if I'm somebody who is accused of maybe possessing an illegal controlled substance, and the police arrest me because I have an outstanding ticket that I haven't paid, and in my pocket is a small bag of methamphetamine, and the officer asks me, "Is that your methamphetamine?" This is, again, during the investigation. I say, "Yes, it's my methamphetamine." I've now admitted that I had methamphetamine, and an officer saw me have methamphetamine. There may not be an appropriate basis to have a preliminary examination. I've made my admission. The officer is going to come in and testify to what he saw. He's going to testify to what I said. That's going to be more than enough evidence to bind it over to circuit court. So depending on the level of the investigation, there may not be a need to have a preliminary examination. Many times the preliminary examination occurs in cases that have a victim. And the reason for that is that the defendant wants to make sure that the victim is on board with the government to prosecute the defendant. So an armed robbery, a sexual assault victim, a domestic assault victim, the preliminary examinations oftentimes happen in those cases. Why? Because the defense wants to make sure that the accuser is actually able to come to court and testify against them. So in those situations, you'll see a preliminary examination. but oftentimes these hearings are waived at the district court level. When they're waived, they make their way up to circuit court, and the circuit court judge handles it from that point forward. Again, the issues of bond apply from the arraignment on until it's resolved. So whatever bond was set previously, the court may review it if it appears to be a high bond and maybe it should be lower, or maybe it was a low bond and it maybe should be higher. The court can consider that depending on the circumstances, can change the conditions of bond if the court feels as though that's appropriate. So there's a lot of opportunities along the way during these critical stages. And these critical stages, which we've talked about, are an opportunity for the government and the defense to litigate something where a defendant has the right to have his lawyer present. Changes in bond, things like that may take place. So again, to wrap up, this is where we're at up until the second examination, which I will deliver to you the beginning of next week. That is the week of March 30th. The format of how that exam will exist, I will relay to you via email, and then, of course, get you the exam in the manner in which it's appropriate. I'm not quite sure how we're going to do that yet. I got to talk to Western Michigan administration about how I can deliver the exam, and then you can return the exam to me. But this is the material. So end of number 4, that is distance learning number 4, will wrap up the examination material for number 2. I will soon prepare distance learnings 5 through 9, which will take us to the end of the semester. Don't focus in on those things until we've taken the second exam. Again, 5 through 9 will take us to the end of the semester, and then I'll have the final distance learning number 10, which will be a review of things before the final examination. So I'm going to wrap it up there after about, looks like 32 minutes of discussion about this topic, and we'll see you next time.